new ban on assault weapons is currently on hold.
Control laws designed to ban so-called assault-style firearms is now on hold.
Virginia's ban on assault weapons cannot be enforced.
This comes after a long legal battle over the constitutionality of this new law.
The law violates the Second Amendment by banning the commercial sale of firearms.
What happens when a state government passes a sweeping prohibition on popular firearms, threatens law-abiding citizens with jail time, and then just weeks later, completely surrenders in court and begs to freeze its own law? That is precisely the bizarre spectacle unfolding across the Commonwealth of Virginia right now, leaving political strategists baffled and Second Amendment advocates claiming a historic victory. In a dramatic turn of events that virtually no one saw coming, state officials who boasted about disarming the public are suddenly backing away from their own legislative flagship, locking their own law in legal deep freeze until at least 2027. To understand how this massive political backfire happened, we have to look back at the chaotic sequence of events that started earlier this year. State lawmakers, led by high-profile Democrats including State Senator Saddam, Azlan, Salim, and Delegate Helmer, pushed through a controversial piece of legislation known as Senate Bill 749. This legislation set out to ban the sale, manufacture, purchase, and transfer of a massive category of popular semi-automatic firearms, specifically targeting semi-automatic rifles, handguns, and shotguns equipped with common features or magazines capable of holding more than 15 rounds of ammunition. When Governor Abigail Spanberger officially signed the bill into law, supporters hailed it as a landmark win for public safety. Lawmakers boldly declared that after the scheduled enforcement date of July 1, 2026, the era of these common firearms in Virginia was officially over. The statutory penalties attached to this new law were anything but light. Anyone caught selling or transferring a restricted semi-automatic rifle or standard capacity magazine after the deadline faced a Class 1 misdemeanor, carrying up to 12 months in jail, thousands of dollars in fines, and an automatic 3-year revocation of their firearm purchasing rights.
The state's new law restricting the sale of certain semi-automatic rifles.
Now at 5:30, a state law banning the sale, purchase, and transfer of certain assault weapons in Virginia.
Unsurprisingly, this sparked widespread panic throughout the state's retail sector. Small business owners, local gun shop operators, and federally licensed firearm dealers found themselves facing a catastrophic dilemma. Fearing potential criminal prosecution and federal license revocation, hundreds of independent retailers spent the final weeks of June stripping their display cases clean. Popular civilian rifles like the AR-15 platform, standard Glock 17 double-stack handguns, and common home defense shotguns were pulled from store shelves virtually overnight, causing massive financial losses for local shopkeepers who rely on these everyday inventory items to keep their doors open.
Big thing is understanding what this injunction stands for and how it possibly could affect us and how it could affect the clientele that comes inside the store.
Yet behind the scenes, a fierce legal resistance was already taking shape. Prominent civil rights groups, including the Virginia Citizens Defense League, the Gun Owners of America, the Virginia Shooting Sports Association, and the National Rifle Association, teamed up with key state legislators like State Senator Bill Stanley and former Virginia Attorney General Ken Cuccinelli to launch a multi-front judicial offensive. Instead of relying solely on federal courts, these legal teams strategically deployed lawsuits in rural state circuit courts under Article 1, Section 13 of the Virginia Constitution. A historical clause guarantees the inherent right of the people to keep and bear arms. This tactical move effectively trapped the state government in its own judicial backyard, preventing state attorneys from easily transferring the disputes into friendlier federal appellate venues. The first crack in the state's defensive wall appeared in late June, just days before the law was set to go live. A circuit court judge in Lancaster County, Virginia, issued a localized injunction halting the Virginia State Police from enforcing the new restrictions. State officials tried to downplay the setback, suggesting that the order only applied to one specific jurisdiction and that citizens in other counties could still be prosecuted. But that legal maneuver evaporated almost immediately. On July 7, 2026, Judge Jeffrey L. Campbell of the Washington County Circuit Court dropped a massive judicial hammer. In a scorching written opinion, Judge Campbell extended a preliminary injunction statewide, officially blocking all state police officers, local sheriffs, Commonwealth's attorneys, and municipal agencies from enforcing the firearm ban across every corner of Virginia.
The Department of Justice and the ATF say the rule changes are meant to, quote, reduce unnecessary burdens on law-abiding citizens.
Everything now has gone back to the same way it was before it even started.
In his memorable opinion, Judge Campbell pointedly quoted the historical words of St. Bernard, noting that the pathway to hell is often paved with good intentions. He conducted a rigorous constitutional analysis using the groundbreaking framework established by the United States Supreme Court in New York State Rifle and Pistol Association v. Bruin. Under this standard, the government must prove that any modern firearm regulation aligns with the historical tradition of firearm regulations in early American history. Judge Campbell observed that semi-automatic centerfire rifles like the AR-15 are among the most widely owned, common-use firearms in modern history, making a blanket prohibition on their sale and acquisition overwhelmingly likely to violate fundamental constitutional guarantees. What happened next stunned legal observers nationwide. Rather than aggressively appealing the Washington County injunction to higher state courts to defend their prized policy, top officials in the state executive branch completely changed their tune. Virginia Attorney General Jay Jones made an extraordinary tactical retreat, submitting formal requests to state judges to pause and stay all 4 pending lawsuits against the firearm ban. The Attorney General's office openly acknowledged that proceeding with state-level litigation would be an unnecessary waste of taxpayer resources, formally requesting that the law remain entirely dormant until at least 2027. The hidden driver behind this sudden surrender is a pair of monumental cases currently sitting on the docket of the United States Supreme Court. The justices in Washington are set to hear landmark constitutional challenges targeting similar firearm prohibitions passed in other jurisdictions, specifically Viramontes v. Cook County out of Illinois and Grant v. Higgins out of Connecticut. Because these federal cases directly examine whether state governments have the authority to ban semi-automatic rifles and standard capacity magazines. Any ruling handed down by the High Court will instantly set binding constitutional precedent across the entire nation. State legal teams realized that if they continued fighting local battles in Virginia, they faced the humiliating prospect of losing repeatedly in state court, only to have the entire legislative framework struck down by the Supreme Court anyway. This stunning pause has thrown the original architects of the legislation into an unprecedented political tailspin. The confident, triumphant rhetoric that once dominated public press conferences has suddenly morphed into deep anxiety and damage control. In public statements addressing the judicial stay, State Senator Azlan Salim openly expressed frustration over the delay, admitting that if the United States Supreme Court ultimately strikes down these types of bans, lawmakers will be forced back to the absolute drawing board. Senator Salim conceded that if the nation's highest court rules against firearm bans, the state will have burned immense political capital, spent endless taxpayer resources, and accomplished nothing in terms of legislative policy. Meanwhile, the economic collateral damage caused by this legislative experiment continues to ripple through Virginia's business community. Across the state, small independent shop owners are picking up the pieces after months of forced inventory manipulation and market instability, while many retail stores are cautiously restocking popular semi-automatic rifles like the Daniel Defense DD5 DPM SM4 carbines and various handguns featuring 15-plus round magazines. Other merchants remain hesitant. Some larger commercial establishments, such as Grand Top Firearms in Richmond, have chosen to keep their inventory restricted despite the active court injunction, terrified that sudden legal shifts could leave them holding non-compliant stock. This persistent atmospheric fear is a direct byproduct of passing aggressive regulatory policy without considering the underlying constitutional realities. To fully grasp the magnitude of this legal standoff, it helps to analyze how fast the broader legal landscape surrounding firearm rights has shifted over recent years. For decades, lower federal courts frequently utilized a complex legal test known as two-step intermediate scrutiny, which allowed state legislatures to balance constitutional rights against public safety interests. However, the landmark District of Columbia v. Heller decision, followed by the landmark Bruin ruling, completely upended that dynamic. Today, courts are explicitly forbidden from using policy balancing tests when reviewing gun laws. Instead, judges must strictly evaluate whether a banned weapon is in common use for lawful purposes among peaceable citizens. Given that an estimated 20 to 30 million semi-automatic rifles are currently owned by law-abiding Americans across more than 40 states, legal experts agree that classifying the most popular rifle platform in modern history as an illegal weapon faces a nearly insurmountable constitutional hurdle. The political fallout inside the Commonwealth of Virginia extends far beyond gun control legislation alone. This high-profile legislative failure comes on the heels of several other contentious political battles that have eroded public confidence in state governance. Earlier this year, controversy erupted over proposed legislative redistricting maps that critics argued attempted to disenfranchise roughly half of the state's congressional voting base. Millions of dollars in campaign funds and political resources were poured into those initiatives, only to see them crumble under judicial review and public pushback. For many voters, this pattern of passing high-profile, legally vulnerable mandates only to watch them collapse in court reflects a troubling disconnect between political ambition and statutory reality. As the calendar moves toward late 2026 and early 2027, Virginia finds itself in an extraordinary state of suspended animation. The controversial ban on semi-automatic firearms and standard magazines remains completely dead in the water, frozen by judicial order. Citizen gun owners can continue purchasing, transferring, and carrying standard capacity firearms without fear of immediate state prosecution, while state prosecutors and legislative backers are forced to sit on their hands and wait for the Supreme Court to decide their fate. The sweeping restriction that was supposed to redefine gun ownership across the Commonwealth has instead become a cautionary tale of legislative overreach, proving that no matter how much political momentum a law carries through a state capitol, the constitutional rights of the citizens still hold the ultimate veto power. That's it for today, folks. See you in the next video.